Driving, right?
So, and again, this is being recorded for everybody too. So I will drive the slides, hopefully.
Okay, so we're going to get started with a few housekeeping items, and I will introduce both of us. First of all, thank you for joining us today. We're really excited to cover a new topic for us and for Anne, and we're really excited just to focus specifically on school districts. So, first of all, the webinar is being recorded. You heard that. And we will send the recording to all of the registrants. There were a couple people asking if we would send the slides, which we will. You will be on mute. The Q&A is open. It is tested. It is working. So we're good to go. And Anne is really great about fielding questions throughout the webinar. We want this to be, it's your webinar. So we want you to be able to ask questions whenever you need to. Do you want to chime in on anything else, Anne?
Yes, absolutely. It'll make it a better learning experience if you do ask questions, and I will try to answer them in real time as they come in. And what I do with every compliance webinar, because we offer a compliance webinar that has SHRM credit, the second Thursday of every month, is if we're running behind on the webinar, I will stay as long as necessary to answer any questions that you might have. So please put the questions in or comments or anything you might want to say in the Q&A section, and I monitor that as we talk. And I love questions, so keep them coming.
Okay. So I'm Bridget Escobar. I'm the president of CTR Payroll and HR, and you're probably looking at this slide going, oh boy, what did we sign up for? A commercial. I promise you that we will not do that. It'll be very quick, high-level overview of who we are. Just wanted to introduce us, and then we'll kick things right over to Anne for the educational piece. So we are an HR and payroll technology firm. We are based here in Pittsburgh, and we offer really the focus is HR and payroll technology. So we can automate the entire employee life cycle from hire to retire. So what does that really mean? It means that your employees can go online to fill out their application, and then they can go online or through a mobile app to fill out their new hire paperwork. They can enroll in benefits through our system. So we really automate anything that is in the role of payroll or HR. So if you want to kick it over to the next slide, Anne. I wanted to talk a little bit about our expertise with school districts. Because we are a Pennsylvania-based company, we do get PA local and school district taxes. And that seems to be a challenge for a lot of the national providers that you may work with. PA local tax, school district tax is a challenge. As a school district, you do want to make sure that your taxes are accurate for your employees. And so that's something that we do specialize in. We also focus on PSERS reporting. We understand the compliance. We also have customized reports for PSERS that you can use, certification tracking specific to school districts, recruiting, et cetera, et cetera. So that's the end of my quick commercial, but if anybody has questions or wants to reach out, we'd be happy to give you more information. So I want to do a quick introduction of Anne. Anne joined our team as our compliance specialist several years ago. And I always say that she came to us in my darkest hour. It was right after COVID. And I had just done 30 plus webinars, compliance webinars for our clients on every new COVID rule or regulation. If you can remember, they were pumping those out like every other week. And so that was basically all I did that year. And I came to my business partner in desperation and said, we need to hire someone. And I remembered several years ago meeting an attorney who is an insanely fantastic speaker. No pressure, Anne.
You're setting the bar high. I hope I meet it here.
And I said, what are the odds that we can find her? And we did. And so the backstory on Anne is that she had a very long and successful career. I won't say how long, so I won't date you, Anne. But she was with a very well-known Pittsburgh-based law firm. She focused her practice on labor and employment law. She is engaging. And when she is not busy doing webinars with us, she is home with her family. She and her family actually received the Adoptive Family of the Year award from the state of Pennsylvania, which is also a really cool little fact about Anne. So with that, I will turn it over to Anne.
Thanks, Bridget. Yeah, I'll date myself because my gray hair dates me too. I had practiced as a partner in a large firm downtown for about 25 years and had retired to spend more time with my family. So I was sitting around in my bunny slippers when Bridget called. But so they pulled me out of my bunny slippers now and then. And we do a monthly compliance webinar that offers SHRM credit the second Thursday of every month. Last month, it was really well attended, tons of questions. We did the top 5 employment mistakes. In February, we're doing ADA errors and mistakes. So we try to do topics that are timely and apply to people. And the other thing that Bridget didn't mention is in my 25 years with a really large firm downtown, we acted as solicitor to several school districts. And so I did a ton of employment law work for some really large school districts in the area and attended more than my fair share of school board meetings. So I can understand some of the pain that you all feel, some of the problems you have. And that's why with today's webinar, as I do with most of my compliance seminars, I don't want to sit around and read off regulations to you because that would put you to sleep, which, if you have insomnia, maybe that would be helpful. But hopefully we're going to take real life situations and apply them and ask questions and sort of work through what actually might show up in your office at school. Hey, somebody just asked, are these Thursday webinars free? Yes, you don't have to be a client. They're open to anybody who wants to attend. We have sort of an email registration. It's a Zoom thing. Again, you get 1 SHRM credit, and it works just like this, where we send out the recording and the slides and whatnot afterwards, so that you can have and keep it or whatever you want to do with it. So yes, they're completely free. It's free SHRM credit basically, and you can do that. So the way we're going to approach employee leave today is by using a real life example that I think walks into your office with some frequency, but because of relatively new laws and new regulations, we may want to rethink how we handle Emily employee. So Emily employee, she's a tenured high school science teacher. And let me just say, my other connection with school districts is my husband is a teacher. And if we have enough time, I'll tell you all a funny story about when he was on strike, but we'll save that for the end. So she's a tenured high school science teacher. She's been with your district for 6 years. She's an adequate employee. We all know what that means. Not great, but you're not going to fire her. There's no way you could get that through the union. But on your little 3-tier employee performance rating system, she's consistently rated as proficient. She's looking a little green. She tells you that she's pregnant and not feeling well in the mornings. So what does this immediately make you think of, right? There should be a bunch of laws that are jumping into your head right now. She believes that eating saltines and drinking water during class will help her out. And by the way, having had multiple children myself, in addition to adopting some from the foster care system, I really sympathize with Emily here. So she says, I need to eat saltines and water, drink water throughout the day. However, your school has a policy that there's no food in the science lab due to significant chemicals in the lab and risk for contamination or harm. So what do you say? You say, hey, option A, right? And feel free to chime in with what option you like here. I'm sure everybody will pick C, but you say, hey, you can eat in your classroom, but not the lab. Does that sound like a good idea to anybody? Does anybody want to chime in with that? Do you ask for a doctor's note? Nobody wants to be the first one to say what they would do here. All right, we all know everybody's going to offer a catered breakfast and lunch to help her out because that'll improve your employee relations. Let's start with the first one. So the law that applies here is the Pregnant Workers Fairness Act, which came into play about 2 years ago. And in 2023, they issued regulations. And in those regulations, assuming they stay as is, they have what are called predictable assessments. Predictable assessments include basically 4 categories that the Equal Employment Opportunity Commission, which is charged with enforcing the PWFA, assumes you will automatically do, that it's not an undue hardship, and you cannot, with respect to point B, ask for a doctor's note with respect to the need for the accommodation. So one of those predictable assessments is eating throughout the day, drinking throughout the day. And so when we look at this and we say, hey, she wants to eat in the lab, we know that we would have an almost impossible time making the argument that it's an undue hardship for us, because the regulations say, hey, this is one of the predictable assessments to have frequent meals and drinks throughout the day, and you better do it, employer. This isn't an option. You can't possibly meet the undue hardship bar, or it would be extremely difficult. And so we better think of an accommodation for this. What if she leaves the lab to eat? Well, that would be an accommodation. But my husband tells me that the students actually will not be fine for 5 minutes by themselves, no matter what. So we better figure out a way to let her have the saltines and the water in the lab. And frankly, in a high school chemistry lab, this ought to be workable, right? We could have it in a corner somewhere, away from the chemicals. It shouldn't matter. What if she also says, hey, when I'm out eating and drinking, I'm going to need more bathroom breaks too, right? And I'm not going to wait, or I can't wait until the bell rings. And I have 4 minutes and 10 seconds or whatever your bell time is. It always amazes me that school districts have it down to the second like that. I can't wait necessarily, because I just don't feel well, for the bell to ring. So what are you going to do? Just like the eating and drinking, which the PWFA says is a predictable assessment that you automatically need to accommodate, and it would be extremely difficult to establish that it's an undue hardship. Bathroom breaks, more frequent bathroom breaks, are required of you. And it's going to be on you as a district to figure out how to cover that class, because we probably don't want to leave the kids alone for 5 minutes. And it's a problem, right? I can sympathize with everybody who might be rolling their eyes right now, because they're unpredictable breaks. How are you going to cover that, right? You're going to have some system, just like you probably do for emergencies, to have someone step in and cover that. Asking for a doctor's note is off the table with respect to those 2 accommodations, because under the PWFA, it says you cannot ask for a doctor's note. You can't even ask them to confirm that they're pregnant. I've done this similar webinar for other folks, and they said, well, hey, what if somebody is just saying this and they're not really pregnant, and then 3 or 4 months from now, they're just going to tell us they miscarried? How will we know if they committed a fraud on us? Well, the reality is you can't ask for the medical documentation for these 2 accommodations that are predictable assessments. It's based on trust. It's also based, according to the EEOC, on the theory that when somebody's this early in a pregnancy, they might not actually have seen a doctor yet. And so they might not actually have a healthcare provider who could provide a note saying, hey, Emily employee is green and she does need the saltines, or she does need the bathroom breaks. And the EEOC goes on to say, hey, it's common sense. Anybody who's ever been around a pregnant woman knows that these are very real, very common issues. All right, what about pulling out the FMLA paperwork, assuming you're not doing the catered breakfast and lunch? This is optional at this point. I think it's probably a good idea to say to Emily employee, right? We can't ask for a doctor's note with respect to her request for the saltines or the frequent bathroom breaks. But we can say, hey, if you're struggling, and we can put a spin on this, it's not even a spin because this is what the law is and this is ethically what we should do. We have benefits available for you, right? In fact, school districts have really good benefits available. And FMLA is one of them. And she's been with us 6 years. Presumably she's going to qualify. Here's the paperwork. If this becomes more serious and you need time off, here you go. Here's your paperwork. And eventually you're going to need time off for the delivery. So you might as well have the paperwork now. Nothing wrong with pulling it out. You could wait too. You could take the position of, hey, well, she hasn't asked for any leave yet. We'll wait till she's closer to the due date, or she asks for leave, and then we'll hand her the paperwork if necessary. Okay. Well, I was driving the computer here. 1 second. Let me get back to my slide. Okay, so the saga continues. We all know that no employment situation ever resolves easily. So, poor Emily. The saltines didn't work out so well. She feels dizzy. She will now be sitting, she tells us, through all classes and labs and provide instruction during class or lab from her seat in the front of the room. Okay, somebody has asked a question here, so let me try to get over because I did promise to answer questions in real time.
Oh, no, it wasn't a question. It
Oh,
was a
okay.
statement. You keep on trucking.
Okay, sorry about that. That's okay. So she's feeling dizzy, not surprisingly. Do you, A, offer a lazy boy recliner in place of her 1960s plastic desk chair to help her out? My husband assures me that every good school district has a variety of plastic desk chairs from the 1960s. And actually, just as a war story here, we actually had one time an employee for an employer who requested a lazy boy recliner as a reasonable accommodation under the ADA because they had headaches and needed to recline in their chair. So, not necessarily off the table, but probably not appropriate here. If she did ask for a better chair, one that maybe she could tilt or feel more comfortable in as the pregnancy grows, then that would be an accommodation that we would need to look at and determine whether or not it's reasonable. So let's just pretend Emily has, in fact, asked for a chair that's better than the 1960s desk chair that we have provided to her for the last 6 years. What do you say? Now, this is something we could ask for a doctor's note on, right? If we wanted to. I don't think it's a bad idea. I don't think we open the floodgates by giving her one. One thing I want to point out with this is sometimes employers, not just school districts, which are always sensitive to money because you report to the taxpayers and you always have somebody who thinks you did the wrong thing no matter what you do, is that oftentimes employers, when they get a request for the purchase of something for a disability, look at it and say, oh, an ergonomic desk chair, that's like $150, $200, $250, whatever it runs. I'm not doing that. That's too much money. Whenever you use, so not just in this scenario here with somebody who's pregnant, but anytime you use cost as a reason that you won't accommodate somebody, that is the worst possible argument you can possibly make. Because what that does, so when I used to counsel employers, I would say, hey, if we want to argue that something is an undue hardship, we will look at every argument possible, and cost will be the absolute last one. Because if we say the $250 ergonomic desk chair is too expensive for a disability, the EEOC will say, hey, if your argument is cost-based, open up your books to us and show us all the frivolous stuff that you spent money on that far exceeded the $250 for the desk chair. Not only do employers not want to open up their books, although school districts are more transparent, but it's just a terrible argument in general, because I guarantee you that somewhere in your finances, you have wasted $250 on something more frivolous than helping out some poor lady who needs an ergonomic desk chair for her pregnancy. And you might be sitting there saying, especially if you have been around the block in HR, saying, well, hey, pregnancy isn't a disability. I don't have to accommodate diddly squat. That's a very technical legal term there. I went to law school for 3 years to learn that one. I don't need to accommodate that. That is not what the Pregnant Workers Fairness Act says at all. The PWFA says, hey, it doesn't matter that the pregnancy is not a disability under the ADA. We're going to assume it probably isn't. You still need to provide better seating arrangements if necessary, right? So it doesn't matter that pregnancy is not in and of itself a disability that would qualify under other laws. You're still going to do this. And let me point out one more thing, because you don't have enough on your shoulders already with Emily here. So the third predictable assessment is providing seating arrangements. So it doesn't say you have to go out and purchase a new chair for her, but it does say in the PWFA that one of the predictable assessments for which we cannot get a doctor's note is allowing somebody to sit during work. So we've got Emily sitting here. We would have a very difficult time telling her, hey, get off your duff and work, which was option B. And again, please feel free to chime in here if you like. If we say that to her, we have violated the PWFA predictable assessments, which essentially say, hey, sitting during work is a reasonable accommodation. Does that put our classroom at risk at all for behavior? I hope not. But we're going to have to let her do it. What if one of the kids has an IEP that requires frequent check-ins during class? In fact, in this little example, the IEP says a teacher will check in with a student because they have ADHD at least 2 times a class period. There's no para in this class because this is a general ed classroom. So Emily legally has to get up at least 2 times a period to check on the student. Do we agree with that? Well, let's break that down a little bit. And maybe I should mention one of the other things I do when I'm not in my bunny slippers is I'm a volunteer educational advocate. So I have attended way more than my fair share of IEP meetings. And I started doing that in my community because the children we adopted from the foster care were all medically fragile or intellectually challenged. So they all have IEPs. If you have insomnia, read an IEP. What do we think here? So I think we need to look at this and say, we have to let her sit, but we have a conflicting legal obligation that she has to check in with this kid. Maybe we can make the kid come to the front of the room. Maybe the parents will go nuts that we're singling that kid out. Maybe we send a para in for this class, even though we all know we all have a shortage of paras. In fact, one day my daughter, who is legally blind and attends a high school, her para was out. She's life skills. And the assistant principal got to be her para all day. You can imagine how that went. In any event, he's a great guy, but that was a surprise to him to be her para all day. We are going to have to accommodate this. It's going to be a little bit of a hardship to us, but the regulations say, hey, it's not enough of a hardship. You're going to have to comply with both laws simultaneously. We're either going to try to see if we can't somehow work that kid's desk up near her so that maybe she has a chair on rollers. She can roll over to him. Maybe he comes up or she comes up to the teacher. Maybe we send a para in. We need to do something so we comply with both IDEA for the IEP as well as the PWFA. Okay, what about this? And I know on this webinar today, we have school districts that are both inside Allegheny County and outside of Allegheny County. So maybe you tell her, hey, sorry, you're having a problem, but no accommodation is going to be made until we get that doctor's note. Well, we know we're going to violate the PWFA if we say that with respect to sitting down. If you're in Butler, Washington County, is that fine? But do Allegheny County folks have a different issue? Well, we're going to talk about that a little bit more because Allegheny County and the city of Pittsburgh have sick day acts or sick leave acts. And I'm just going to refer to them as the Allegheny County sick leave acts because they're virtually identical that talk about need for time off. They wouldn't necessarily address this directly, but they're going to come into play and overlap the PWFA as we go on here. Okay. Okay, so Emily keeps going. Emily is a no call, no show on Wednesday. Now let's think back when I was drafting these slides and thinking about the example I wanted to use. What happened about a week ago to every school in town, right? Including my husband's district. You were all closed due to severe weather, right? It was a tough day for everybody. So this school didn't close, but there was snow and wind chill and whatever. Lots of griping. Parents think you shouldn't close. Parents think you should close. You can't make everybody happy. Emily's certainly not happy. She doesn't even call off. She just doesn't show up. That's a tough scenario for a school, right? She comes in at 10:30 in the middle of fourth period. Your assistant principal had to cover her first 3 classes because there was a sub shortage and you had 0 advance notice. Your assistant principal was a former English teacher. She had no idea what to do with a chemistry class, and she did not look happy after 3rd period. Thankfully, you got a sub for 4th through 9th period to come in. Now, I have to tell you, I got some of my inspiration here from the day that the assistant principal in my district had to be the para to my daughter. And by the way, just as a funny story, she uses a white cane because she cannot see or cannot see very well. They lost the white cane together somehow when he was the para. But in any event, you've had the assistant principal be the teacher for this class. School started at 7:30. Teachers report by 7:15. Emily says she suffered a significant bout of morning sickness. She was too dizzy and ill even to look at her computer to call off on ASOP or whatever call-off system you use. I know a lot of districts use ASOP. She'll probably be coming in late other mornings too, she tells you, given how this pregnancy is going. These late arrivals will be random and unpredictable. Your assistant principal spotted Emily as she walked in the door this morning and told Emily, I had to cover your class. Thanks a lot. And we can all see this happening. We can't have this happening. I couldn't even find the subnotes to teach your class. Parents will be furious because their kids aren't learning, and I missed an IEP meeting where I was supposed to be the Leah. Don't let this happen again. At a minimum, you must follow our policy and call off by 6:30. You hear about this and what? Give up? That is sometimes what HR feels like doing, right? Okay, so option 1 is you do give up, you spin around in your desk chair and start checking Expedia flights for Hawaii. You've had enough. This is like herding cats. Sometimes I used to feel that way when I attended the school board meetings. That's a little side note there. What do you do with this? All right, what laws are we now looking at? We're looking at the FMLA, we're looking at the PWFA, and we're looking at the Allegheny County, City of Pittsburgh sick leave laws, even if you're not in Allegheny County, and I'll get to that in a second. So let's talk first about the assistant principal. So would it be a good option to discipline the assistant principal? I mean, she's clearly having a great day anyway, so why not add to it, right? It'll probably really help your career out too. You want a career advancement. Well, there's different ways of handling these things. We have a problem because of what the assistant principal said. This lady has job protected leave available to her under both the PWFA, the FMLA, and the Allegheny County sick leave laws. And we'll talk about if you're in Butler or Washington or Armstrong counties, how that could even apply to you. You cannot retaliate or interfere with somebody's leave under those acts, right? So we haven't even reached what we're going to do with Emily yet. Our first headache is the assistant principal. And it's not that we have to discipline her, but we do have to rein her in somehow. And we need to reverse the statement that she has made. And so the first thing, and if you are like the HR generalist, obviously we're going to run this up the flagpole, because one of the important things for HR is, I think, always having your team with you. You should have people who support you, stand by you, and will support the decisions that you make, right? And so that may be drawing in the your director of HR, maybe the superintendent, whoever you need to get support, that we need to counsel the principal about what she said, because she's probably just frustrated. She probably doesn't mean anything by it. And we need to sort of reverse course on what she said, because that's like a smoking gun, what she said for FMLA interference. It's a problem. So that's one kettle of fish that we need to deal with, which is counseling the principal about the law's requirements, that she can't say or do things like that again. And we need to, when we meet with Emily, back off of the principal's statement that this can't happen again, but rather that we're here for support and we need to work with this, because this is a difficult situation to have a no call, no show randomly occur. Okay. Do you discipline Emily? Of course, we're going to bring in the union and we're going to have the Weingarten rights and all that good stuff. Because you strongly suspect that snow and wind chill played a greater role than her pregnancy with respect to her tardiness. In fact, you've heard her coworkers joke that Emily always comes in late after a Steelers game, or if it's too cold out. We're going to tell her this can't happen again. I pounded the desk for effect there. No, we don't discipline Emily. That would be a problem. But here's what we're going to do. So under the PWFA, as well as the FMLA, we can require advance notice. However, especially under the PWFA, if the employee is unable to give us advance notice, they must give us notice as soon as practical. And that's a huge gray area. What is as soon as practical? Do we take her word for it that she was so ill she couldn't even look at her phone to call off? Maybe, maybe not. Remember, the first slide was Emily is an adequate employee. She's proficient in your assessments of her. She's not your star employee. This is certainly a situation where she should, if she doesn't already have it, you ought to be thrusting the FMLA paperwork at her and telling her to return it. She obviously has at least 15 days to do that if we haven't already given it to her. She ought to be turning that in. Under both the PWFA as well as the FMLA, we can get a doctor's note to substantiate the need for coming in late, and perhaps even the issue with respect to whether or not such leave would be foreseeable or unforeseeable, and prevent her from calling in a timely manner. And those forms should help guide us as to how often we should expect this to happen, as well as how far in advance we should expect notice when it does happen. And remember, on the FMLA in particular, you have rights if that form comes back and it's really squirrely as to what's been put in there. For instance, if it says unknown or no idea, we don't accept a form like that. That healthcare professional needs to give an educated estimate. And so we would ask for clarification of a form like that said something squirrely, that didn't give us any parameters of this. What happens if you're in Allegheny County or the city of Pittsburgh? Well, that just complicates matters for you incredibly, because the Allegheny County, city of Pittsburgh sick leave laws talk about a person can have up to 40 hours of unpaid but job protected sick time, right? For which you cannot ask for a doctor's note, even when they pull something like this. And maybe it's not pulling something like this. Maybe this was a legitimate concern, but it still allows us to get the FMLA paperwork. So even though the Allegheny County or city of Pittsburgh sick leave laws would say, hey, you can't ask for a doctor's note unless it's 3 consecutive days of absences. And even then, the doctor's note you get is really, really crummy. If you have followed along with that, all the doctor's note needs to say, and it only has to be from a healthcare professional, not necessarily a physician. It just needs to say, hey, Emily employee had a condition that warranted her being out. It doesn't have to say what the condition is. It doesn't have to say anything more than that. But remember, we still have the FMLA. We ought to be pursuing that paperwork. We ought to be looking at what's going on at this point, because the no call, no show is a huge problem. What if you're in Butler County or Washington County and you're like, those poor Allegheny County schools, pity them. Well, guess what? The Allegheny County and Pittsburgh paid sick leave laws apply to you guys if your employee has worked in Allegheny County or the city of Pittsburgh. And so you're sitting there saying, no, they're always in my school building up in Butler or over in Armstrong or where. They're never in Pittsburgh. But let's think through that a second. And I'll use my poor husband, who will love me later, as an example. So he has been with his school district a long, long time. He frequently attends conferences, or he has done some things that are like educational awards or educational workshops or whatever it might be, that even though he's not in the Allegheny County, when he attends those things for a week here or there, they are in Allegheny County and in the city of Pittsburgh. We know that we have an affirmative obligation as an employer, even if we are not in Allegheny County or city of Pittsburgh, to track his hours and say, okay, science teacher went to the Pittsburgh Zoo, which he has done, to do whatever in the world it is he's doing there. And he spent X number of hours or X number of days down there, or he did the conference down at the AIU, and therefore, he spent X amount of time, or whatever it might be. We have an affirmative obligation to track those hours that he spent in Allegheny County or the city of Pittsburgh. And for every 35 hours that he is in one of those locations, or Emily employee might have been in one of those locations, he's going to earn 1 hour of Allegheny County or city of Pittsburgh sick leave time. That's going to protect him in a situation like this, even if you're not in Allegheny County. I hope that makes sense. So for those of you in Allegheny County, hopefully you're already tracking this and and it should be overlapping your existing PTO and your existing leaves. But if you're outside of Allegheny County, know that you're probably going to have some folks running around, teachers, principals, whoever it might be, in Allegheny County that are going to be accruing this time, and they can accrue up to 40 hours, and it can roll over from year to year. So even if Emily employee only accrues 10 hours this year down in the city of Pittsburgh or whatever, it's going to keep accruing. Okay, somebody asked a question and said, is the employee obligated to use paid sick time when she arrives late? That depends on your policy. And I would strongly urge you to have policies that would require that. To say, hey, when you're on any type of leave, whether it's job protected or not, we're going to run through whatever PTO bank you have, concurrent with whatever other leave rights you have. So the common scenario, and that's a great question, and what I would recommend now, all of you probably have unionized workforces, so you can't just unilaterally make changes if you don't have this. It's probably a subject of bargaining. But the ideal situation for the employer is to have the PTO, the FMLA, the PWFA, and the Allegheny County City of Pittsburgh leaves run concurrently. Because what we don't want to have happen from an employer perspective, and this doesn't mean we're mean or unethical, we're just being good stewards of our resources. We don't want them to run through, some teachers have a lot of PTO saved up, run through all their PTO, and maybe that's 3 weeks of PTO, and then take 12 weeks of FMLA, and then come back and say, and we'll talk about this a little bit more, I want 40 weeks of PWFA leave. That puts them out over a year. That's not the goal that we're looking for necessarily. And plus, most people do want to be paid. Most people find that important. So most people do want the sick time paid during these job protected leaves under any of these acts. Okay. What about the rumor that you've heard? So really, really difficult. Probably most of you know this already. A rumor without any substantiation that she's calling off because of the Steelers game. Hey, we're out of the playoffs. Or because of the crummy weather that we have had in Pittsburgh that has made me personally rethink whether or not I want to go south. A rumor is not going to do it for us. Now, if we had other evidence, right, that might be a different story that we would discipline based on, but that would be a case-by-case basis. That would be something that I'd actually pick up the call to pick up the phone to your solicitor and talk to them. If we think we're going to discipline somebody who's protected by all these job protected leaves because we think we have evidence that she's misusing it.
For the question,
All right.
Ann.
Yes.
And I'm sorry if maybe you're covering this later, but what if you have, if this unpredictable leave, right, continues
Mhm.
to happen, and then you start getting parent complaints
Yeah.
about it being disruptive,
Mhm.
what can you do? Does that give you more leverage? And could you force this person into kind of a leave situation just so you could provide more continuity for education?
Yeah. So that's a great question. So Bridget, that is so the question, just so everybody make sure everybody heard it, was, this teacher's floating in and out unpredictably. We don't know when she's going to show up. She's usually missing the mornings. So her classes in the mornings are getting a very different education than the classes in the afternoon. And we've got parents now who are calling in and being like, hey, this is unacceptable. This is not what I pay my tax dollars for. This can't continue. So what we would look at is she has job protected leave under the FMLA. There is no undue hardship exception there. So it's not like we can say, hey, you can't just randomly show up. We can probably pressure her to do better in the call off area, but you can't just randomly she's randomly I'm sorry, let me start again. She's randomly calling off, but the FMLA says she's allowed to do that, right? Assuming that we have a medical certification that verifies the need for it. There is no, like there is with the PWFA, an undue hardship argument. It's just an automatic, she gets it provided she has the right documentation for it. To the extent that we have parents complaining, that's on us. We have a tension between providing FAPE, right, a free and appropriate public education to all students, and honoring the FMLA. And we're going to have to find a way to do that. And that may mean an additional expense for us, which nobody wants to hear. But we can't deny the FMLA leave, the intermittent FMLA unpredictable leave. There are special rules for intermittent FMLA leave when as a teacher, when the leave is predictable and it's towards like the last 5 or 3 weeks of school. But this is not the case here. This is an unpredictable leave, which is actually more difficult for us. There's nothing we can do about the FMLA leave, assuming she has the right paperwork. We need to be proactive and figure out a better way to cover that class so that the parents stop complaining. The one thing I do think we can address with her is the failure to have the subnotes. Now, the first thing I would check is that there really was a failure to have the subnotes. Remember our assistant principal who had to cover this class and said, hey, I couldn't even find the subnotes. Now, our assistant principal might not have looked in the right spot, or she might have been overwhelmed or whatever it is. So we want to make sure that that really is the case, that there were no subnotes. If there's no subnotes, that's a standard practice and policy and requirement for most districts to say, hey, you must keep a subfolder or whatever that's available for substitutes. And if Emily hasn't done that, then that's something we can address with her. It can either be sort of what I'd call an informal counseling, if we have to do it that way, or it can be discipline. And that in large part is going to depend on how we treat other people who have blown the sub-note requirement in their classrooms, because that can happen with some frequency. Okay, so, and of course, we're going to get that FMLA paperwork in. Moving along. Okay, Okay, we are now in the situation where Emily is upset. Your assistant principal's comments were the final straw. We didn't reverse course quickly enough or well enough, and she's still upset about it. She doesn't feel very supported, and she runs, not walks, to the EEOC and files a PWFA complaint, right? The Pregnant Workers Fairness Act. The EEOC is the one that takes those complaints and investigates them just as they would any discrimination complaint. Concurrently, she runs to Allegheny County and complains that you violated the Sick Leave Act. She's very industrious. I don't know why you rated her as just proficient. She also goes to the DOL and files an FMLA complaint. Now she can't work at all. She's too traumatized. The stress is not good for the baby. The complaints arrive on your desk, and I'm sure it's a Monday morning when they arrive. Your first call is to, well, all of these people, right? Except D, maybe Emily, to tell her exactly what you think about her. That's probably the wrong call to make. But we should have employment practices liability insurance as part of our coverage for a district that covers employment claims. One of the worst cases I ever saw as a practicing attorney was an employer, not a school district, but an employer who had employment practices liability insurance, EPLI. When they were sued and had a complaint in front of the EEOC, for whatever reason, it never occurred to them to put their insurance carrier on notice. There is an affirmative obligation in every insurance policy to put your carrier on notice so that they can be part of the litigation strategy and response team with respect to any complaint. This company did not do it. They handled the EEOC complaint all by themselves. I'm not saying they handled it poorly, because they were a really sophisticated company. What they were thinking, I don't know what happened to them. Handled it by themselves. They got sued in court. They were halfway through the litigation when it dawned on them that they had insurance for this. What did the insurance carrier say? They denied coverage because they said, hey, you cannot handle this litigation, these complaints in this litigation all by your lonesome for over a year and then expect us to pick up the coverage, because we probably would have settled this way back when. Whether they would have or not, that's a different story. That became a huge issue because there was a lot of exposure in this case. And again, why they didn't think to call the insurance folks and put them on notice, right? To call the company, put them on notice. You've got these complaints. That's usually enough to trigger a notice. An employee saying, hey, I'm going to sue usually isn't, but when you actually get the complaints from the EEOC or the DOL or whoever, that triggers notice. Obviously, your solicitor, we got those calls with some frequency and talked about that and talked about how to handle it and who was going to do the litigation and whatever. Of course, your superintendent. This ought to be run up the flagpole so that everybody is aware of what's going on here. One thing I want to stress here, City of Pittsburgh, if you look at their sick leave law website, both Allegheny County and City of Pittsburgh actually have pretty good websites regarding their sick leave laws. They have model posters. They have Q&A, FAQs, whatever. One of the things the City of Pittsburgh has that they claim they're going to fill out on their website is a wall of fame or a wall of shame, depending on how you want to look at it. And so what they anticipate doing on their website is, if you're an employer who exceeds the requirements of the City of Pittsburgh, you get to be on the wall of fame, school district, whatever, or employer, whatever, they're on the wall of fame. They did fantastic. They have exceeded the requirements under the City of Pittsburgh Sick Leave Act. Then there's the part of the website that says these employers meet the bare minimum. So you're complying with the law, but you're not going over and above. And then there's the wall of shame, which they expect to fill in based on the complaints that they're investigating, that says, hey, this employer, ABC, who's now out there in the public for everybody to see, blew it in a big way, and they're on the wall of shame. They did not meet the City of Pittsburgh Leave Act requirements because of whatever they did. So just be aware of that. Okay, what did she do? You look at these complaints, and In them are allegations that you made a fuss over the IEP student who needed frequent check-ins. That really interfered with her rights under the PWFA. And to prove her point, she listed the student's name and attached his IEP SDI page, that's a specially designed instruction page, that talks about frequent check-ins. She also said that you, HR person, in particular, interfered with her FMLA rights. What do you do with this? So first option, you call the director of special ed and tell her, hey, it's your problem now. She mentioned an IEP. I don't touch IEPs. This is all you. Plus, that, that director of special ed, she doesn't seem to do much anyway other than attend those IEP meetings. Let her figure this out. Well, we definitely should call her because this implicates the privacy implications under IDEA. It also implicates C, your assistant superintendent who's in charge of FERPA requests and issues, because both the teacher and you as a district are subject to FERPA. This is arguably a breach. It's not even arguably, it is a breach of those privacy rights under both the IEP, IDEA, and FERPA. We've got an issue. We need to see if we can minimize the alleged damage by the disclosure. That could be calling up the EOC and asking for those documents back, which, by the way, I've had this issue with the EOC. They won't give them back to you. They look at this as, hey, they're enforcing discrimination laws and things like that. They don't care about your FERPA or IDEA issues. They're not going to give it back to you, or at least not readily. You might ask if they can at least redact the names. It's a real problem. You might consider telling the students' parents what has happened if we think this disclosure is a problem. But that's an issue that we would have to work through depending on exactly what's been disclosed and how much of it we can get back. What if she didn't put the student's name information in the complaints, but you need to reference it in order to defend the complaints? Well, we're going to use de-identified information to do that. We should never be submitting, hey, John Smith, our student, has an IEP and he needs this. We can talk about it in much more general terms. FERPA does not have an exception for this type of litigation to disclose personally identifiable information. It does if, like, the student sued us for failing to do something or doing something we shouldn't have done. We could use PII to defend it, but not in this situation. What about your favorite lunch spot? Come on, people. It's been cold. Let's make reservations. After all, this can't possibly come back on you personally, right? I hate to tell you wrong. So one of the things I always like to point out in FMLA seminars that I have seen go terribly wrong for employers of all types is that the FMLA is one of the few laws that allows for personal liability of anyone in the company who interfered with or retaliated against the protected employee with respect to FMLA rights. And so I have seen lawsuits that name the employer as well as the HR manager or director, or like in this case, the assistant principal, for interfering or retaliating against the person who's trying to take FMLA. That's a personal liability situation, not just the district is being sued. So you need to be aware of that liability that exists out there and how you're going to handle that. All right. And by the way, that's one way when you talk to the principal about what she said to kind of make her get in line if we have to say, hey, there's personal liability for anybody who interferes or retaliates on an FMLA leave. Sometimes that threat of personal liability is enough to make them play nice in the sandbox. Okay, I know we're running out of time here, but let's try to finish this up. I want to be respectful of everybody's time. Okay, Edward employee shows up on your doorstep. You've done climate surveys and bystander training, and he knows what to do. By the way, do you know what a climate survey is? It has nothing to do with global warming. So a year or two ago, the EEOC came out with guidance, which does not have the same force and effect as regulation, and it was under the prior administration. So whether they'll continue to promote this or not, we don't know. But they said, hey, employers really should do climate surveys. And what they mean by that, although it's not required, is, hey, you want pulse of your employees to see if any of them feel like you're violating the laws. Essentially, you're saying, hey, come punch me on the chin. I want to know if you think I have a problem here. And in some ways, it's not a bad idea because it's always better to handle problems internally if you have them than to let them go externally. So climate survey is essentially surveying your employees to see what they think of you and your compliance with EEO laws. Bystander training is training all coworkers to learn how to stand up for fellow coworkers who might be the victims of discrimination or harassment or a violation of the laws, whatever it might be. So you've done that training because you followed the guidance from the EEOC, and Edward employee shows up on your doorstep. He's the science group head. He tells you in no uncertain terms that Emily has wept on his shoulder and he cannot believe how the district is handling her. In fact, he's the one who encouraged her to talk to the EEOC, DOL, and Allegheny County. He's disgusted, and he just wants you to know that he intends to make the union and all co-workers aware of what, well, we can't say it, you are and how you treated Emily. What do? Do you tell him to go back to his class? You send him a write-up later for his aggression and swearing at you? You don't have to stand for this. Well, I do think you can write him up for swearing at him as long as you have consistently written up everybody else in the facility who has ever sworn at you or who might be similarly situated and has sworn at another administrator. That might be a tough bar to achieve. What about Emily? She's been missing. And of course, he's now protected because anyone who helps promote or stands with somebody who's filed charges, they are protected from retaliation or discrimination as well. All right, Emily's been missing a ton of time, so what do you pay her? Yes, we can force her, as somebody already asked, to use the sick time, assuming that's written into our policies. You think you've heard about something new under the FLSA? Well, yes, the FLSA rolled back the weekly salary threshold for what you need to pay, the salary basis of what you need to pay folks who are exempt. However, teachers aren't subject to the salary basis test under the FLSA, so that really isn't going to impact you here. You're really looking at trying to make her burn through her PTO concurrent with all job protected leave. But wait, since she said she's out due to this trauma and she doesn't know when she's going to return, she didn't provide a leave date, maybe you can just terminate her for an indefinite leave of absence, right? That would be a possibility under the ADA if we had an indefinite leave of absence. What I want to point out here is, and you might say, well, hey, she's going to use up the 12 weeks of FMLA leave very quickly, and she won't have delivered the baby yet. Gosh, we're going to have another opportunity to terminate her at the end of the FMLA. The PWFA says that it is sort of automatically reasonable to assume a minimum 40-week job protected leave of absence. So whenever you have a PWF situation, even if you have FMLA in play and the Allegheny County leave laws and whatever, know that the PWFA regulations feel very strongly that 40 weeks is a reasonable leave, unless you can prove, and it's your burden to prove, to show that it's an undue hardship, which is going to be tough according to the EEOC. Okay, so before you can make up your mind about firing her, and we've got 2 minutes here, Emily calls in and says, hey, you know what? I need some income. How about accommodating me? I'd like to do my job via telecommuting. You hang up and no, crying is not an option. Is that a reasonable accommodation? The PWFA says it can be if it's not an undue hardship. I would take the position that for a classroom, even though we did this during COVID and allowed teachers to telecommute and teach your classes that way, we did that when the students weren't in the classroom. This is a completely different ball of wax. I would argue it's an undue hardship, and we're not going to accommodate that. So I think I have ended right on time. If anybody has any questions, please feel free to let us know. And again, we do the Thursday webinars. And if you're interested in the top 5 employment mistakes, that is recorded and you can access that from January. And we'll be doing the ADA here coming up in February. Thanks,
We're going to
everybody.
send Kara mentioned we're going to send the link to upcoming webinars in the email that's going to include the slideshow. from today.
Great.
All right.
Stay warm out there, everyone.
Thank you. Take care.
Oh, let me see if there's a question here. Oh, you're quite welcome. Quite welcome. I'm glad it was helpful. Okay, everyone, take care.